I disagree, Your Honor. I think that the judgment of this court is going to be that there is no case or controversy. That's not an advisory opinion. That's disposing of the case in front of the court. And I think the court is free to state the reasoning that we are advocating in this case as part of its judgment that there isn't a case or controversy under Article 3.
I mean, it still feels a bit unjudicial, if I may say, so that the question is not just resources, but something broader than that. And I take the point that each of these is a jurisdictional issue and that there's nothing jurisdictionally precluding us, that this is a matter of prudence. But when you look at a case that's dead as a doornail several times over, you know, the case has been dismissed by the plaintiff, the defendant is totally different, the defendant's website, everybody agrees, is now in compliance with the ADA. So this is like dead, dead, dead in all the ways that something can be dead. And to use that case as the vehicle for deciding an important issue, an issue that probably is going to need to be decided at some point, but surely can come up in a live case, I guess it just doesn't seem like something that a court should be anxious to do.
Well, just to address some of the subsidiary issues Your Honor mentioned, the question of whether the updates to the website made the case dead is actually disputed among the parties. The First Circuit held and respondent continues to argue that that didn't moot the case. So I think that would be a difficult opinion, maybe not difficult, but the court would have to—
Well, it's not disputed that the hotel's website is in compliance. The only thing that's in dispute is what the issue is with respect to like hotels.com. But the hotel is now owned by somebody else. The hotel is in compliance in terms of its own website. And, you know, most importantly, the plaintiff has dropped this case.
Right. So in terms of the sale of the hotel, so Acheson Hotels remains the defendant in this case. It would be the subject of any hypothetical injunction and fee award. So we don't think that moots the case unless there's a court order substituting the new defendant, which never happened. So I'm not sure that's a reason not to decide the question presented.
Yeah,
but look,
I think you're avoiding the main—
okay. I understand Your Honor's argument that if they've dropped the case, why are you deciding this big question? And yes, that is certainly a discretionary consideration that the court should consider in deciding how to dispose of this case. It is a weight on one side of the balance. And I just think that the weights are greater on the other side of the balance when you consider the institutional considerations that should lead the court to decide the question presented, such as a concern about blessing the legal strategy in this case of respondent, which will be invoked in future cases by other litigants. Because the same thing is going to happen. A plaintiff is going to file a large number of lawsuits, and in the rare case that goes up, the plaintiff will abandon the case at the last minute, and if there's pushback from either the court or the defendant, the plaintiff is going to say, look at what happened in the Acheson case. The Supreme Court said it was perfectly fine to adopt that legal strategy.
But if it's going to happen again, why don't we wait until